Hello and welcome to our webinar on consumer leases. My name is Jemima McCorn and I'm a senior lawyer in Legal Aid's Civil Law Service for Aboriginal Communities. I'm joined by Jenny Hanson from our Community Legal Education Unit. Today I'm going to be giving you a snapshot of consumer lease issues and what you can do to help your clients. We only have half an hour, so we won't be covering everything, but I do hope that you find it useful in your work. Firstly, why are consumer leases a problem? So consumer leases have been on the radar of financial counsellors and consumer lawyers for a while now as products that can cause significant financial stress to vulnerable consumers. They offer a way of obtaining household goods in fortnightly instalments, which make them attractive to consumers from an affordability perspective, particularly when there are often very few other alternatives available. The overall cost can be extraordinary, and we've seen a prevalence of non-compliance with responsible lending obligations in this market. We've also seen a number of rogue traders, some of whom have left the market following work by Legal Aid, CLSACs, financial counsellors and ASIC. Before I get into the guts of it, I just want to flag some potential changes to this market next year. There is some draft legislation that's been put forward for consultation, and you can see that on the Commonwealth Treasury website if you'd like to take a look at it. Importantly, it's going to provide a cap on how much consumer lease providers can charge, and there's a number of other really great consumer protections that we're hoping will come through in that legislation. We'll likely put on some training next year once these changes are introduced. At this stage, I just wanted to flag that that's something on the horizon. So over to definition and regulation. As most of you would know, we're looking at the National Consumer Credit Protection Act. So I might refer to that as the Credit Act throughout this webinar. The Credit Act deals with all aspects of loans and credit, and as you might be aware, it sets out different definitions and regulations depending on the contract type. So if you've got a credit card or a payday loan or a consumer lease, you might have different types of definitions and different types of regulations. I'm not going to go into all the detail of those today, but I will highlight some important aspects. Before I do that, I just want to mention that if you are talking about the actual goods in the contract, so things like the goods being faulty or unsafe, then that's where you'd be looking at the Australian consumer law and the consumer guarantees that people have in that law. Again, I'm not going to talk a lot about this today, but it's just important that you understand if you're talking about the goods, go to the Australian consumer law. If you're talking about the contract, go to the Credit Act. The Credit Act covers most household rental contracts, but there's an important distinction when you're looking at these contracts, and that's whether or not there's a right or obligation to purchase. So what that means in a practical sense is, does the contract say the client will own it at the end? Or does it say something like the consumer has no right to own the goods, or the consumer can make an offer to purchase, but the provider has no obligation to accept? So if it looks like the contract says that the client will own it at the end, and we often see that in things like motor vehicle contracts and motor vehicle leases, that's going to be a sale by instalment contract. The 48% interest rate cap is going to apply, and all the laws that relate to credit contracts are going to apply. But if it's the latter, so the consumer has no right to own the goods, then you're going to be looking at a consumer lease, and that's where it's important to understand that there is currently no cap on the costs that a consumer lease provider can charge. So the first thing I wanted to do was just draw your attention to that distinction between a sale by instalments contract and a consumer lease contract. So if you've determined it's a consumer lease, and most of the contracts that we see in the market for household goods like fridges or laptops are in fact consumer leases, it's important to know that there are a couple of other scenarios where the credit law is not going to apply, and therefore your client won't have the protections of that act. And so they are things like where the contract period is for less than 4 months, or where the contract is for an indefinite period. So that's where the contract doesn't say anything about how long or how short the contract is. And the third scenario is where it relates to an employment contract. So that's going to be, some people get caught up in that where they've salary sacrificed car leases. And that's, again, common in the community sector and might be for some of your clients where the salary sacrificing a car lease and therefore the Credit Act is not going to apply. They won't get those protections. But other than those scenarios, the National Consumer Credit Protection Act is going to apply, and you will have some of those usual protections in the Act that you would likely be familiar with. Things like the providers have to be licensed, they have to follow responsible lending laws, they have to provide hardship arrangements, and there are special disclosure rules for consumer leases. So things like they have to detail the type of goods, the amount that's payable each fortnight, and the total cost. So there's just some examples of the laws that will apply once you've worked out that it's a consumer lease and you've worked out that none of those exceptions apply. So what kind of problems do our clients have? There's a list there of some examples. I think you'd be familiar with some of those scenarios. I just wanted to paint a picture of the range of problems that people might have and draw your attention to the fact that depending on the problem they have, you might take a different approach. So we've got up there that the client can't afford the payments or the client stopped paying. And so that might be a hardship issue or it might be a responsible lending issue. And that's going to depend on the facts of the case that you have in front of you, and we'll go into that in our case study later. Things like where the client didn't appreciate how much they would pay, or the client thought they would own it at the end, own the goods at the end, you're going to want to look at things like disclosure and misrepresentations and ask the client, what happened at the time that you signed up. I think a lot of the other ones up there speak for themselves. The goods have been lost or stolen or pawned. There's some problem like that with the goods. I do think that often with consumer leases, we have clients that are really quite unaware of the rights that they have in relation to consumer leases, and that they don't necessarily see these issues as issues that you might be able to help with or that a lawyer might be able to help with. They often approach you because of some other financial hardship, and it'll be up to you and up to lawyers that they see to make them aware of the rights that they have and the obligations that the provider have that they should have followed. So later we'll talk about the kinds of arguments that you can use depending on the issue. So you've worked out that your client's got some kind of issue, and now you want to answer these questions. And I'm suggesting these questions because in my experience, no matter what the argument you're going to use or no matter what you're going to do for the client, these are the basic things that you're going to need to know the answer to. So what are the goods worth and how much has the client paid? They're going to be critical questions to working out what kind of outcome you want and also how much effort you're going to put into it. You're going to need to work out where are the goods and what does the client want. So are the goods still with the client or have they been repossessed? Does the client want the goods or do they want to return them? What else does the client want out of this scenario? So that you can try and work out how you can get that outcome or talk to the client about what kind of outcome is really realistic. And then the last one I've got there is, can I see the contract? So you're going to need to look at the contract to work out what kind of contract it is and what kind of laws apply. As I just talked about, you're going to need to work out, is there a right or obligation to buy? Because that's going to change the arguments that you make. As lawyers, we would normally request this kind of information in writing by sending a letter asking for all the contract documentation and information about payments and also information about responsible lending compliance. But practically, there's going to be times when as financial counsellors, you might just want to do that over the phone with the lessor or even just ask the client for those for the documents if they have them. Negotiation. What is the goal? So if you've worked out what the problem is for your client and you've got some basic information about the things we just talked about, my suggestion is that next you want to think about what's the goal? What's the best outcome I could get for this client? And you will then think about the arguments. But in my experience, if you think about this first, you're going to be able to, suit the arguments to your needs. So in my experience, there are two important factors that go into the assessment about what the best outcome is that you can get. The first is, does the client have the goods and want to keep them? And the second is, has the client paid more than the retail value? So they're questions that you've probably just found out through doing your inquiries, but now you want to think about, what does that mean for the outcome that I'm going to start to try and get in a negotiation? We will look at the arguments next, but if you think there's pretty poor conduct on the face of it and you think, I've probably got a strong argument here, you're going to want to aim for something where the client has to pay the retail value or thereabouts and keep the goods. There's going to be lots of other scenarios and we'll go through some of them, but the principle here is about trying to get the client into a position they would have been if it wasn't for the trader's poor conduct. Next, you're going to think about what arguments can I use? And you might want to use a couple of them, or you might just want to stick to one that's particularly strong. Just to go through some of them quickly. The first one, breach of responsible lending. This is probably the most common argument that we use in consumer lease disputes. And so that's going to be things like where the trader has misjudged how much the client earns, or they haven't made inquiries about their expenses, or they've simply not made the right assessment about whether or not the contract is affordable and suitable for the client. The next one is breach of disclosure obligation. So as we talked about earlier, you're going to want to see a contract that complies with the disclosure obligations. It's got to set out how much they pay each fortnight and the total cost, among other things. You could make a hardship application, so that you would be very familiar with these. That's where things might have changed for your client and they need a variation to the contract that's going to enable them to meet the obligations while they experience this financial hardship. Is there a breach of a 48% interest rate cap? So this is only going to apply in a sale by instalments contract. But if you do have a sale by instalments contract, it's important to check that 48% interest rate cap hasn't been breached. And then the last one there I've got is about breach of debt collection guidelines. So if the client is already in arrears and the consumer lease provider is in the process of trying to collect the debt, you're going to want to talk to the client about how often are they calling, are they coming round to your house, are they sending you text messages, when do you get all of these? It might amount to harassment, and if you've got a concern about the amount of sort of contact that the provider is having with the consumer, go and have a look at the debt collection guidelines. You can get them off the ASIC website or the ACCC website as well. So the list of arguments happily continues. We have misrepresentation about the contract terms. Again, this is a fairly common one we see with consumer leases, and that is that the consumer lease provider has told the consumer something different to what the contract terms say. And so that might be something about ownership, like, you'll own you'll own the goods at the end, when in fact the contract doesn't say that. Or things like there might be a provision in the contract that says you can gift it to somebody else, but the consumer's never been told that. So if you're looking at things like that, that's misrepresentations. The next one is unconscionable conduct, and this is probably one that you're going to want to refer to a lawyer, but it's really about really bad conduct where the consumer lease provider has taken advantage of the client's vulnerability. Perhaps the client has a disability, the consumer lease provider's ended up in their home selling them something, they've signed a contract that really doesn't give them the rights that they should get, things like that, you're going to be looking at unconscionable conduct. And I should say misrepresentation and unconscionable conduct apply to all kinds of consumer contracts, not just consumer leases. The next one we've got there is ACL breaches, so that's the Australian Consumer Law. So that's where the goods are perhaps not in working order, or they weren't fit for purpose, or they weren't of acceptable quality. There's a lot of different consumer guarantees that you can have a look at, but you're going to want to use that where you're talking about the goods. There's something wrong with the goods, you go to the Australian Consumer Law. The last one I've got there is that the trader isn't licensed. So if you look up the trader's license on the ASIC website and discover they're not licensed, you're going to want to contact ASIC pretty quickly, because that's an important breach that ASIC are going to want to investigate. I just would also like to refer you to the Credit Law Toolkit. That is a really great kit that can help you identify the issues in your particular scenario and, help you work through, say, a responsible lending argument. So it's just a great kit that you can use if you're dealing with these arguments in more detail.
Okay, so I'm going to give Jemima's voice a rest and read out the case study here. So, your client Shirley is a grandmother living with her son and 3 grandchildren in a remote Aboriginal community. Shirley's sole income is a disability pension, and you realise when talking to her that she has trouble reading and writing. Shirley has come to talk to you because she owes $2,000 on her energy bill, and the company is threatening to disconnect her electricity. She also runs out of money each fortnight, borrowing money from her daughters. You prepare a money plan and see that she is also paying $180 a fortnight to Best Rentals. She tells you she signed up for a bedroom suite when the grandchildren moved in. She's been making all the repayments through CentrePay and doesn't want to have to return the goods because she thought she would own them. So, Jemima, what would you do?
Thanks, Jenny. So, using the model that I've just gone through today, the first thing you're going to want to look at are what are the issues that we see for Shirley. So we know that she's in financial hardship. We can tell that because of the energy bill. And obviously you're going to want to deal with that energy bill up front and make sure that you have spoken to the electricity provider and Shirley doesn't get her electricity cut off. After that, you want to find out when the energy arrears date from and has it got worse since she signed up to Best Rentals. She has some trouble reading and writing, so she probably doesn't know the total cost of the contract or the true terms and conditions of the contract. Sometimes I like to ask clients, how did you think this was going to work? What did you think would happen? You'd pay the money each fortnight and what would happen throughout the contract? She also wants to keep the goods, but you can see from what she's told you that she can't keep paying that amount each fortnight. She clearly can't afford that. So that's an issue that you're going to have to deal with in helping Shirley and negotiating an outcome. So the next stage is, what more do I need to know? So the first thing that we talked about earlier was, well, how much has she paid? You could do a rough estimate based on when Shirley says she signed up and the fact that she's paying $180 a fortnight through CentrePay. You could also contact the company to get that information, and you can also get that information through CentrePay. So Shirley herself could go on to the Centrelink website and get the information through CentrePay. The next question is, what are the goods worth? Again, you could do a rough estimate based on the quality of the goods and what you think they're worth, or you could contact the company. You're also going to need to check the terms and conditions. Remember, we talked about that you're going to need to look at whether or not it's a consumer lease. So you're going to want to get those terms, the contract and the copy of the terms and conditions from the client or from the company. And then once you've done all that, it's then that you would look at what arguments could you use. So you could use a responsible lending argument or a hardship argument. I would say probably you're going to go down a responsible lending argument because, assuming that she was in arrears at the time she signed up, and you can see she's supporting all these other people, you have a look at her bank statements and you realise there's probably a responsible lending argument. There may also be a misrepresentation argument. So you're going to find that out when you ask her what happened at the beginning of the contract. What did they tell her about the contract, and what didn't they tell her about the contract, and what did she understand? There may also be an unconscionable conduct argument, and you'd need some more facts on this. But if Best Rentals did actually end up selling her the contract via door-to-door sales, they ended up in her home. It might depend on what kind of disability she has. So if she has a cognitive disability that would have been obvious to the trader, then you might, again, be looking towards unconscionable conduct. And really that's something you're going to want to be talking to a lawyer about. Okay, so we'll return to Shirley in a minute, but I just want to talk about the kinds of outcomes that you might want to be trying to get. And this is going to depend on how strong the argument is that you've just identified. So I've got some ideas up there about the outcomes you could be looking for. You might want to get an agreement that the consumer owns the goods, so ownership is passed, and they get compensation, so they get money back from the provider. Or maybe they just get a waiver, so no more money to pay. I often talk about those in terms of a walkaway. So the client has the goods, they have no more to pay, they get released from the contract. That would be a walkaway scenario. Or the client might want to return the goods, and that might, you might be looking at returning the goods where the client, say, hasn't paid very much money. If you talk to Shirley and actually she's only been signed up to this contract for 3 weeks, well, you might be wanting to talk to her about actually return the goods, walk away, get a better deal, or return the goods, get some compensation, and then get a better deal. Also, you might want to be negotiating a new payment arrangement, and so and a new total, and that would come up where you're dealing with a hardship variation. And then lastly, it might be that you're trying to look for replacement goods. So maybe you've got an Australian consumer law argument about the goods not ever being fit for purpose or not being of acceptable quality, and then you're wanting to argue that you get replacement goods. So these are the different kinds of outcomes that you might be looking for, depending on how strong your argument is and what your client wants. So negotiation and complaints are really about how do I get to the outcome that I want using the arguments that I've identified. So the first step is internal dispute resolution, or IDR, and that, if that doesn't work, leads on to external dispute resolution, which we call EDR. So I would refer you to ASIC's Regulatory Guide 165 that deals with the obligations of providers in managing the process of IDR. It sets out that there's a 45-day period in which to resolve IDR before you can proceed to EDR. So with EDR, we have the Financial Ombudsman Service and the Credit and Investments Ombudsman. So which one of those you go to depends on which one the provider is a member of. So you can just head on over to the FOS website or the CIO website, search for your provider and work out which one you've got to go to. I've also got their ASIC and CORD. So ASIC, you might consider making a complaint to ASIC where you think this is probably happening to other consumers and you want ASIC to have a look at it, or you think it's really targeting a group of vulnerable consumers, or you think that the trader is, the conduct is particularly bad and you want ASIC to look at, investigate it. And you can do those at the same time that you do IDR and EDR. There's nothing stopping you doing that. And the last one I've got there is court. So obviously you're going to need to refer to a lawyer if you think court is the option to go for. I guess court would be an option really where you're looking at lots and lots of money. So, I don't know, $20,000, $30,000, court might be an option. Or where the conduct happened a while ago. So if you're starting to come up against sort of 6 years since the conduct, it might be that there are time limits to apply to the court, and the client will want to get some legal advice about that. And then I've just got there at the end, do I need to refer to a legal service? So obviously with court you do, but it might also just be that you think, oh, I've identified these issues, but it's a lot of work and I don't have time and the service doesn't have time, I'm going to refer to a lawyer. Or that you want a bit of support from a lawyer to be able to run these matters and you've not run many of them before, we'd be happy to help you through the process. Or you think it's just particularly complicated and a lawyer might want to be giving advice on these issues. So at that point, you would refer to a legal service, and we've got some of that information at the end of the webinar.
So part 2 of the case study about Shirley, you discover Shirley has been paying for about 5 months and has paid about $1,800. You estimate this is probably what the goods are worth. So 2 questions. What kind of outcome would you be looking for? And secondly, how would you get it, Jemima?
Thanks, Jenny. So, yeah, you looked into it a bit further and you think you've probably got a pretty good argument, because Best Rentals would have known the payments would put her into debt if they had properly assessed her outgoings. So that might be that you discover that the energy arrears were always there and that really Shirley was living week to week and these payments were going to put her into debt, and also that $180 represents a fair percentage of her income given what she's also paying for. So if that's the case, there's going to be a breach of responsible lending, and that's the argument that you're going to want to use. You could also argue that the conduct is unfair. Perhaps Best Rentals approached Shirley at her home. Perhaps she has a cognitive disability that would have been obvious, and that they should have really, not entered into the agreement with Shirley. So for Shirley, if you got an outcome which saw her own the goods and get a walk away, that is that she wouldn't have any more payments and she wouldn't have any further liability and she'd own the goods, I think that would be a pretty good outcome, given that she's paid for 5 months and she's paid about what the goods are worth. That would put Shirley in a position where she's paid for the goods that she has in her possession, and she's no worse off than she would have been if she hadn't entered into the contract, but rather she'd gone and bought the furniture from somewhere else. So in terms of how would you get that outcome, as the financial counsellor in your region, you might be able to contact the provider directly. If they're a local provider, you might want to do that on the phone, and you might be able to negotiate that quite quickly over the phone. But you might have a provider that doesn't want to talk to you about these issues or is not keen to negotiate, and that's when you might set out in a letter what your argument is. And so it's in that letter that you would say that you are starting the internal dispute resolution process and that you expect that it will take 45 days to resolve. And that's where you would set out the argument that the concerns that you have, the laws or the arguments that you think apply, and propose a settlement that the provider should agree to. So let's say you do that and the provider comes back and says, oh, I don't agree with any of these things, but, we'll knock some money off it, and Shirley just needs to pay us another $1,000 and then she can stop paying and she can own the goods. So there you're in a situation where, you're going to get Shirley to own the goods, which is good, that's what she wants, and you didn't have that before, but she does need to keep paying another $1,000 more than what the goods are worth. So that's where you're going to have to weigh up, what does Shirley want to do in this scenario? Perhaps she can pay it in smaller installments that are manageable, or perhaps you go back with a counter offer of $500 or something like that. Or, you do have scenarios where clients are really outraged by what's happened to them and they do want to proceed with external dispute resolution because they're quite strong about the arguments that they have, and that's when you would proceed to external dispute resolution. So that's about weighing up what have you already got and what does the client really want in the scenario. They might feel okay about it because they think, I just want it wrapped up, and if I just agree to that, then that will be good. Or you could maybe say, well, let's have one more go at it, give another an offer of say $500 and see where that gets you. Okay, so that really brings us to the end of the webinar. I hope that's all been really useful to you. We've just got a slide there about where can you get some more information. So there are legal aids across the country in each state and territory. You can go onto the websites to have a look at where the nearest ones are to you. In Legal Aid New South Wales, we have a consumer law specialist team and an Aboriginal service, so feel free to contact either of those if you want some support in your work. We also have community legal centres all across the country that you're no doubt connected with, and again, if you're not, have a look where the nearest one is to you and connect with them. And you've also got consumer credit legal services, so specialist consumer services, and they're listed on the right of the slide that are, again, all across the country. So I'm going to wrap up there. Thanks for listening.